appeal in the matter of Mariana and others and BHP and another.
Yes, Mr. Chief.
I hope the court knows the representation and that I can skip over that.
Yes, I think that's very practical.
Thank you. There are only two matters that I think I need to mention before I delve into my submissions. The first is I'd like to thank, and I'm sure Mr. Gibson joins me in that, we'd like to thank the court for making a huge amount of pre-reading time available last week. We, on our side, the appellants, may have been a little over-ambitious in terms of the reading list that we gave the court, but I hope, nevertheless, that it will have been of some use. I think the respondents were rather more astute by suggesting that you read the skeletons and then follow whatever references take your interest. But nevertheless, I hope the reading list does not prove to be too ambitious.
Well, I'll have something to say about that in a moment, but anyway, let's deal with your other point.
Yes. So far as the timetable is concerned, I've agreed a timetable with Mr. Gibson. The plan is essentially I will open today and tomorrow. Mr. Gibson will then start at 10 a.m. on Wednesday, continue on the Thursday afternoon and the Friday morning, again with a 10 a.m. start, and I will then reply on the afternoon of Friday.
Yes, thank you. That's satisfactory. We'd already been notified of that, but thank you for confirming it.
Thank you, my Lord.
Well, some thanks due on our part to everyone for having done a lot of work to get all this practically set up. And at one point it looked as though I wasn't going to have enough space, but I now think I am. Speaking for myself, and I think for my colleagues, although it will be useful from time to time, and maybe necessary from time to time, to look at the bundles on Opus, because there's more on Opus than is available in the appeal bundles, I will be primarily using hard copy, and those are the references that I will need. I think that in court, although we've made use to some extent of the, obviously, of electronic versions out of court, that's what we'll all be using in court. The point I wanted to raise was this. We have indeed done a good deal of pre-reading. I think pretty well everything that we were asked to read by both parties. But it's led us to this, to want to make this point. This is not the kind of case where you can say, well, the court's done a great deal of pre-reading, everyone understands the facts, and we can now just get on with the law. On the contrary, I think in many aspects, the law is less difficult than making sure we fully understood the facts. So there will certainly be points at which we will require to be taken to the underlying evidence, because I don't say this particularly critically, but at some points in both skeletons, rather sweeping statements are made about the facts, sometimes with a reference and sometimes not, but we want to see exactly what that is based on. And a point spins off that, which is that even in the appeal skeletons, and much more so in the trial skeletons, which are from time to time incorporated by reference, there is reference to documents which are not in fact in the appeal bundles. We've had one example of that already with the Venice 19 witness statements, but there are others where, although we have to a greater or lesser extent been able to find them by going into the trial bundle on Opus, that's not very satisfactory. Strictly speaking, all documents that were referred to in the skeletons should have been in the appeal bundles. Anyway, we are where we are, but the result is that we will, from time to time, I'm sure, be looking at the trial bundles, and we will want hard copies of any documents that are referred to in that way. And the sensible thing seems to us to be to have a running extra bundle of documents produced in the course of the hearing, set up in any way that seems sensible, tabbed and paged, but beyond that probably it'll just be a question of whichever one gets referred to first will be in tab 1, and so on. You won't be able to produce them instantaneously if we ask about them, but we will want them produced as soon as possible. And we'll keep the bundle up to date as we go along. We already need to have in it the 19 witness statements about which you were already asked, but other documents will, I'm quite sure, emerge. The other thing, this may sound rather disciplinary, but COVID has not totally gone away. HMCTS has a standard number of people who are allowed in any court, and I think the parties were told that it would be 25. I was told before we came in that there were in fact considerably more than that. I haven't done a quick head count. Did the message get to you that you should try and reduce yourselves to 25, and if you can't, I need to know why everybody needs to be here. It's all been live streamed, so there's no need for people who are not taking an active role to be present. I can see they may want to be. Was an exercise done before we came in to reduce the numbers to the permitted maximum?
Not as such, but I think what your Lordship has said ought to be self-executing, and those, therefore, who need not be here will, I hope, leave, essentially, so that we can limit ourselves to 25. I had hoped, I'm sorry, there's obviously been a failure of communication. This problem only came up at the last minute. I hoped you'd been told before we came in. It's rather undignified for me to look at everyone. People now have to walk out. I should clarify. The instruction was loud and clear by email. The only reason why I didn't refer to that as such was because the clerk of the court, a moment ago, trying to assist, I think, and conscious that the 25 limit had been exceeded, raised the possibility of asking for your permission.
Oh, I see.
For that number to be exceeded, but I don't think that it need to be exceeded.
Well, I'm not going to spend time counting numbers. If anyone is here who really doesn't need to be here, I'm not going to ask anyone to leave now. I really think that after the adjournment, the short adjournment, we should have people who there is a real need to be here. It is all available on live stream. It's not a question of access to open justice being in any way interfered with. Okay, let's get on.
Thank you, and yes, absolutely.
Oh, I'm so sorry, one moment. Lady Justice Carr has been given a better chair.
Thank you, so would it disappear behind the screens? That's much better. Thank you very much indeed. Thank you.
Your comments about the additional hard copy bundle containing opus material that's not already in the hard copy bundle is totally understood. And in fact, I was going to suggest that we have a travelling additional bundle of this kind.
Yes.
If I can therefore start with my submissions proper, there is one preliminary topic that I should address before I delve into the four topics that are an issue on the appeal, and that's the question of fresh evidence. Since the parties are agreed that the court can read all of the fresh evidence de bene esse, I propose to address any remaining disputes in relation to that in the course of my submissions as and when it's relevant, rather than as a self-contained topic.
Yes, thank you. We had assumed that was the course, and that certainly seems to us to be sensible.
Thank you.
That's all right, isn't it, Mr. Gibson? I can't see why it shouldn't be. Yeah, thank you.
The second point I want to make is that, and hopefully this will shorten matters somewhat, and it's that we don't propose to object to the admissibility of the fresh evidence that the respondents wish to rely upon, and which they served in response to ours in relation to the so-called novel system and things of that kind. The court therefore will not need to trouble itself with the issue of admissibility. However, just to be clear, I am not by this to be taken to be admitting the accuracy of what is said, save insofar as what is being said is actually corroborated by documents that are exhibited to the relevant statements. I'm not even sure that anything turns on that, but precautionarily I'm simply making, I just want to make clear that I'm not to be taken to be accepting the truth of all that is stated. The third point in relation to fresh evidence is that we do maintain that evidence in relation to the post-hearing developments concerning the judicial reorganisation of Samarco is both relevant and admissible on the appeal, because it is critically relevant to the question of the claimant's ability to obtain full redress in Brazil, which is the central foundation of the respondent's own argument that it wishes to maintain on this appeal by way of additional ground, that the that the present claims amount to pointless and wasteful litigation.
Is this the correct analysis, and it may not be, that insofar as we are considering whether the judge made any error, any reviewable error, we ought to confine ourselves to the material that was in front of him? If we take the view that he did make a reviewable error, we may have to make our own decision. For that purpose, it is open to us and in principle desirable to look at the most up-to-date position. So on that basis, the further evidence would be admissible, but it's not strictly admissible to say the judge got it wrong on the material in front of him. That you would have to introduce, well, I'm not quite sure what, on some form of Latin martial, but it's a great deal less straightforward.
Yes, well, if I need to, I do rely on Latin martial, and I do say that there are special grounds for allowing this evidence, given the nature of the arguments. But just to go back to the distinction that you've just drawn, it's not quite correct to draw this clear line of demarcation between, on the one hand, whether the judge made an error on the basis of what was before him, and if he did, the question of what evidence then you may be able to take into account if you were to exercise his discretion or his evaluation, or to reconduct his evaluation of the question of abuse. And the reason for that is because the other side, by way of their respondent's notice, seek to support his decision by reference to an argument, namely that the claimants have the ability to obtain full redress in Brazil. They seek to support his decision by reference to that element, in relation to which, you may recall, and I'll come back to in a moment, he made no finding. And so the position, therefore, is slightly more nuanced than the sort of more black and white.
Well, it's probably not sensible to discuss this in the abstract at this stage. You may well be right. I rather suspect it's the sort of point that's not going to be decisive at the end of the day, but we'll have to see as we go along.
But are you referring here to the respondent's contention that what may have been only observations should be elevated to findings? Is it that part of the respondent's notice you're referring to?
Essentially, yes.
Right.
Yes, exactly. So, starting therefore with abuse of process, if I may, I propose to deal with that under 5 broad headings for convenience. The first is...
Just one moment, if you will, Mr. Chuchoy.
Yes.
Yes.
The first is the supposed irredeemable unmanageability of the present claims by the English court. The second, what we contend to be the judge's erroneous characterization of jurisdictional factors as giving rise to abuse of process. By jurisdictional factors, I mean factors going to whether England, as distinct from some other forum, is the appropriate jurisdiction for the trial of the claims. Third, the proposition that the claims amount to pointless and wasteful litigation because, so the respondents say, full redress is available in Brazil. Fourth, the question of Henderson and Henderson abuse, based on the respondents' contention that they could and should have been sued in Brazil. And then finally, the question of collateral attack, based on the respondents' contention that the present claims amount to an impermissible challenge to pre-existing Brazilian court decisions. These broadly reflect our grounds of appeal, or the combination of the grounds of appeal that we've adopted in our appeal skeleton. Some of our grounds of appeal and our arguments relate specifically to certain claimants, or types of claimants, such as the 58 large claimants, the municipalities, the large businesses, the churches and the utility companies that are not covered by Renova programs per se, or to the judge's failure to distinguish between the positions of different claimants. But I don't propose to address those particular topics as distinct topics, because the nuances that arise in relation to different claimants, in my view, are best dealt with under the 5 broad headings that I've just identified. So that will hopefully simplify the structuring of my submissions. Before I delve into the detail of those 5 points, I just remind the court of the test that is applicable on appeal in relation to the question of abuse of process. The judge quoted a passage from Aldi Stores at paragraph 70 of the judgment. So this is bundle A, tab 9, paragraph 70, which is on page 236. And in fact, it may be that if the court were to look first briefly at paragraph 70 of the judgment.
So sorry, did you say bundle A?
Bundle A, yes.
Authorities bundle A, and did you say page?
I'm so sorry, it's my mistake. I think it may be bundle B. Oh no, sorry.
No, you're talking about the judgment in bundle A.
Oh, it is A, yes.
I'm so sorry, I thought you were taking us to all these stores.
Well, in fact, let's
No, I mean, no,
well,
I don't care what you do, just I didn't know what you were trying to do.
let me try again. Let's keep the bundle of authorities, tab 4.
Tab 4. Yeah.
Thank you.
Can I just get one thing off my chest? I have never seen a trial bundle of authorities that's been organised alphabetically. They're nearly always organised chronologically, which is much more useful, or they're occasionally by different subject matters. We've got used to it, but
We'll
let's do it again.
certainly bear that in mind for the next case. I'm afraid. Yes.
Say no more about it. I've got
yes.
it off my chest now. Yeah, where were we going?
So, my lord, so just very briefly, the facts of that case were, well, if I can ask you briefly to read the head note, letters F to H, on page 748. And then over the page, 749 to the end of letter B, just below letter B, just above per curia. And then if I could please ask you to go to paragraph 16 on page 762, where the essence of the test is set out.
You want us to read paragraph 16?
Yes. Sorry, it's a little long, but
No, it's fine.
It'll be quicker if you
No,
read
no.
it to yourselves.
Yes.
So it's a slightly curious test in the sense that it's not quite the usual discretionary, the usual review of discretionary exercise of review of a discretion, the exercise of a discretion, but because there can only be a correct answer, what that effectively means, in my respectful submission, is that if you believe, in the light of the evidence before you and the submissions advanced to you, that the wrong answer was arrived at, then that must be a basis for intervention. But of course, the practical way in which one gets to that conclusion would involve looking at whether the judge took into account irrelevant factors or failed to take into account relevant factors or reached a decision that on the material before him he could not reasonably have reached. Maybe there's no real daylight between those two positions, because if irrelevant matters have been taken into account and relevant matters have not been taken into account, and the decision is outside the reasonable range of decisions, it must be pretty hard to conclude that it's nevertheless the correct answer. But that's the test, and I think it's obviously important that the court be aware of it. If I turn to the first topic, which is irredeemable unmanageability, there are three specific aspects of that topic, the notion that the judge referred to in his judgment, that are important to bear in mind. The first is the importance attached by the judge himself to the issue of unmanageability of the claims in his evaluative assessment of whether the claims were abusive. The second is the question of principle, whether unmanageability of claims is of itself a legally valid ground of abusive process. And the third is whether the judge's conclusion that the claims were irredeemably unmanageable was reached on a false basis. So if I deal with the first of those aspects, in the importance attached by the judge himself to the supposed unmanageability of the claims, there is a dispute between the parties as to the extent to which the judge considered unmanageability of the claims to be of itself a sufficient reason for striking out the claims, without his having to reach a conclusion as to the claimant's ability to obtain full redress in Brazil. And that's the key point. We take the position that the judge did decide that unmanageability of claims was of itself a sufficient ground to strike out the claims, independently of the claimant's ability to obtain full redress in Brazil. By contrast, the respondents say that unmanageability of claims was merely but one strand of the judge's overall reasoning in favour of striking out. In one sense, this particular dispute is not critical because the respondents positively rely on the additional ground that the claims are pointless and wasteful by reason of the claimant's alleged ability to obtain full redress in Brazil. So either way, it will be necessary to consider the merits of the full redress argument on this appeal. But it remains essential, nevertheless, in my submission, to note the central importance that the judge himself attached to the supposed unmanageability of the claims as being of itself sufficient, a reason to strike out without having regard to the issue of full redress. Because this feature is material to what we say was the judge's flawed approach to the evaluation of the considerations that bear on whether or not the claims are an abusive process. If I can start with the judgment, if you look at page 239 of tab 9 of Bundle A, which is where the judgment should be. The heading grounds just above paragraph 77. So this is where the judge basically explains, paragraph 77, he explains that he has categorized the respondent's central contentions for a finding of abuse under individual headings. The first such heading is the practicability of managing the claims in England, and you can see what's said there in paragraph 78. Then there's another heading just above paragraph 79, which is the topic of
the respondents will
irreconcilable
refer to the
judgments.
ballot, the second half of paragraph 77, won't they? So that suggests taking a broad view of everything. I know you're going to come on to other passages.
Yes, no,
but
absolutely.
just
Let me get one thing straight. There's absolutely no doubt that the judge discusses a number of topics in his judgment, not just the question of unmanageability of claims. Obviously, that's clear for everyone to see. The narrow question that I'm addressing, because obviously the fact that a judgment may say things about 10 topics doesn't mean that the judge considers all that he has said on all of those topics critical to his reasoning. So that's the distinction that we're on to at the moment. And the point I want to make is this, that having identified the question of practical manageability of the claims as being a convenient heading, if you then go forward to paragraphs 99 onwards, you will see that the judge starts off by saying in 99, of course, the claimants are right to point out that generally a claimant is entitled to choose to sue who she wants in the event that more than one party may be liable in respect of the same losses. It is not normally for the court to dictate where such choice must fall. This rule, however, is not absolute, as is illustrated by the decision in the Wyeth case. And he then refers to that and also the earlier Jamil and Dow Jones case, the libel case. And then he goes on to refer in paragraph 101 that in this context it is to be noted just how thin were the claimant's suggestions as to appropriate procedures to deal with the claims proportionately. Little more was predicted than the need for the formation of a GLO, etc. And then if you look at 102, his reference to not permitting an abusively unmanageable claim to proceed in the hope that its abusive unmanageability would catalyze compromise. And then a criticism of the claimants for not having devised a workable procedural mechanism for resolving the claims in 103. And then in 104, in all the circumstances, I am entirely satisfied that these claims would be not merely challenging, but irredeemably unmanageable if allowed to proceed any further in this jurisdiction. And then what he goes on to do in 105, all the way through to essentially 114, is he identifies a number of factors which one would normally regard as being forum non-conveniens type factors, concerned with, for example, language, the need for translation of a large number of foreign language documents, the location of witnesses, the application of foreign law, and so on, as being essentially additional reasons why the claims would be unmanageable. And then you see the conclusion in 115, in the first part of 115, that whatever the chances of any given claimant obtaining full redress in Brazil, it is almost a certainty that she will not achieve it in England because of the claimant's agreement to pay a success fee to their solicitors. And then he briefly considers at 116 to 119 why the claimants might think they're better off suing in England, but he takes the view that that collective optimism was deeply flawed and irredeemably flawed. And then he reiterates his conclusion at 120 that he was satisfied that it has been clearly proved that these claims amount to an abuse of the process of the court. Up to that point, the judge had not considered the respondent's argument that the claims were abusive because the claimants were already entitled to full redress in Brazil, and the claims were for that reason pointless and wasteful. That was the next heading in his judgment. And so his conclusion of abuse up to that point, based on the unmanageability of the claims, we say was clearly reached without reference to the claimant's ability to obtain full redress in Brazil. And this interpretation of the judge's judgment is not only borne out by the passages that we've just seen, but it was explicitly confirmed by the judge himself very shortly after he delivered his judgment. There was a further written judgment from him, which you will find in Bundle N at tab 51, dealing with the question of permission to appeal and costs. And
which bundle?
Bundle N, tab 51. So this was a detailed and considered judgment, which involved the judge not too long, but a couple of months essentially, after he had delivered his main judgment, revisiting his judgment and addressing the criticisms of that judgment.
I don't think it matters. I've got this at tab 10 in Bundle A as well, at 314.
Yes, you're quite right. That version is slightly different because I think it was then delivered in the formal court format, which is at tab 51. And in particular, the version at tab 10 is different because it doesn't contain the judge's rulings on costs, for example.
Right. Okay.
So it may be better to use the version at tab 51. I apologize if you've already made markings at tab 10. Yes, and I'm reminded that the version at tab 51 of Bundle N is in fact the version that was before the Court of Appeal on the 52.30 application. So if you look at paragraphs 36 to 39 in particular, whilst addressing one of the grounds of appeal and explaining why he was not impressed by that ground, he says in 36, well, rather than read it out, if I can ask you to look carefully at 36 to 39, especially paragraphs 36 and 38.
Yes, when he refers to futility or futile in paragraph 36, one might think out of context that was more a reference to pointless and wasteful, which itself involves the availability of full redress.
In isolation, I agree, could
but no, well,
have that
but I
connotation.
think it's clear he there means futile in the sense of futile because they're unmanageable.
Exactly.
It's not quite a comfortable use of the word, but I agree that's what he must mean.
And we will see later, in fact, what his concept of futility was in this judgment. It was a concept of futility that he arrived at, or a conclusion of futility that he arrived at, independently of any assessment of the adequacy of the redress in Brazil. But I need to build that up a little bit more before we get to that point, if I may. But before we leave this document, if you also look at paragraph 67 to 71, in particular 67 and 68. And indeed 69.
Yes. Is there any authority on the question of the legitimacy of interpreting a judge's judgment by reference to what they say subsequently in response to a permission to appeal application? One does come across it from time to time. It's always struck me as slightly awkward, although probably inevitable. You're not aware that anyone this court has ever considered the point?
I'm afraid I am personally not aware of any specific authority at the point.
I obviously see the common sense of it, and I don't think it's suggested we can't. But if there had been any authority on it, I'd quite like to know what it was. Don't worry, that's fine.
I'm certainly aware of a number of cases in which, faced with the arguments on permission to appeal, the judge has given essentially further reasons.
Yes.
In refusing permission to appeal, and that, in my experience, has always been treated as simply part of his reasoning of the judgment.
Yes, so have I, but in other contexts, one is often very chary about allowing a decision maker at a subsequent event to explain, well, what I really meant was this, or, well, I know I said X, Y, and Z, but I should have mentioned also A, B, and C. Anyway, there we are. I'm sure that it is the usual practice, so let's leave it there.
Yes. But as I say, this in my respect submission is really supportive of what is.
Yeah, you say you can see it anyway from the structure of the judgment.
In the event.
But
if you were in doubt about the matter,
yeah,
then at the very least it seems sensible.
No,
to
well, we get the point. I think you've made it sufficiently clear.
Contemporaneous judgment from the same judge. So what we say is that in the light of the judge's uncompromising reiteration of the position, it cannot seriously be disputed that the central foundation of his conclusion of abusive process was his view that the claims were irredeemably unmanageable, irrespective of the claimant's ability to obtain redress in Brazil. So that's the first aspect, the centrality from the judge's own perspective of the concept of unmanageability of the claims. The second aspect that I want to deal with is the proposition that can't be a legally valid ground of abusive process. And we say that the judge in this regard was fundamentally unsound in his reasoning for essentially four reasons. Or the lack of soundness in his reasoning can be looked at in four different ways. First, in terms of inconsistency with the respondent's own case before the judge. Secondly, inconsistency with the authorities cited to the judge and indeed referred to in his own judgment. Thirdly, inconsistency with the claimant's fundamental right of access to justice in respect of admittedly arguable claims. And fourthly, inconsistency with the existence of the English court's very wide range of case management powers, including with respect to group actions. So inconsistency first with the respondent's own case before the judge. I think I can take that very briefly. If you look at bundle I, this is the witness statement of Mr. Michael, the fifth witness statement of Mr. Michael.
And the application notice. Where's the application notice?
Don't
worry, we'll find it. The actual application to strike out and stay.
No,
don't worry. It's reflected in the...
in my head right now, but I'll come back to that in a moment, if I may. If I can show you paragraph 163 of Mr. Michael's statement, and this is page 1674 of the bundle. And you will, if you read the introductory paragraph or part of paragraph 163, you will see there what is said.
I found the application. It's C11.
C1, yes, you're faster than me.
So interestingly, the abuse limb was actually the last of 3 grounds.
It was, yes, absolutely. And one of the, of course, what's happened in this case is, and it's one of the aspects that I come to when I address the question of what we say is the erroneous characterization of jurisdictional factors as being as providing a basis for abuse, is that because all of this was argued together, the whole thing became one big pot into which essentially any point that could conceivably be relied upon as essentially telling the claimants, why are you here, basically, putting it bluntly. Anything that could be used for that purpose ended up being used for that purpose. That's how it basically ended up, because of all those limbs of the application. But I'll come back to that in a moment. So that's the first aspect of inconsistency, and we say that the respondents were obviously right not to seek to rely merely on the sheer number and diversity of claimants and the resulting scale of the litigation as being of itself abusive. Now, of course, it may be said, well, so what? The respondents didn't argue it that way. That doesn't make what the judge said wrong. And this is what then takes us to inconsistency with the authorities. The judge was quite careful in setting out a number of relevant authorities in his judgment. And one sees that, for example, at paragraph 47, under the heading Abuse of Process, the legal starting point. So that's going back to Bundle A, tab 9. You will see he identifies the classic statement of the law in Hunter and Chief Constable of West Midlands, and the test of abuse there is put in terms of the court's inherent power to prevent misuse of its procedure in a way which, although not inconsistent with the literal application of its procedural rules, would nevertheless be manifestly unfair to a party to litigation before it, or would otherwise bring the administration of justice into disrepute among right-thinking people. And then if you look at 48, quotes from another case, and an abusive process was described there as a use of the court process for a purpose, or in a way which is significantly different from the ordinary and proper use of the court process.
I think that's the formula that he picks up in paragraph 120.
Indeed.
It's not really apt to the kind of abuse that he found, is it?
Not at all, no. Not at all. That's really, you jump right through to my conclusion in relation to this particular aspect of inconsistency. But if you then look at 53, the quotation from Johnson and Gore Wood, which dealt specifically with the Henderson form of abuse, which specifically focuses on situations where a party is being vexed twice in respect of the same matter, and was therefore the target of unjust harassment by the claimant. And whilst it's true that in that passage Lord Bingham stated that there had to be a broad merits-based judgment which takes account of the public and private interests involved, and also takes account of all the facts of the case, he was careful to emphasize that attention should be focused on the crucial question whether in all the circumstances a party is misusing or abusing the process of a court by seeking to raise before it the issue which could have been raised before. If you then look at 55, the quotation from Dexter, you will see that worthy of emphasis is subparagraph 6 on page 231, where Lord Justice Clark says, the court will rarely find that the later action, that's, he posits a case by A against B first, and then a case by A against C later. And he says in subparagraph 6, the court will rarely find that the later action against C is an abusive process, unless the later action involves unjust harassment or oppression of B, the initial defendant, or C, the new defendant. And then if you go forward to 57, where the judge started to refer to the authorities in relation to group actions, including in particular the Wyeth case.
So did you take issue with paragraph 56?
I agree that there could be a potential argument of Henderson abuse, potentially, yes, where there are two parallel actions and therefore a multiplicity of proceedings. But that's not per se concerned with the manageability of the claims. That's a different point concerned with unjust harassment or unfair conduct targeted at the relevant defendant. And I'll come back to that.
Can I ask this? What is a court supposed to do with a claim which is genuinely unmanageable?
Well, the usual way in which it happens, in my respective submission, is that if a claim is felt to be unmanageable, the court deploys its case management powers to make it manageable.
No, but
Now,
that's you're changing the goalposts.
Well,
I quite understand you may say that it's a very bold thing to say, and the court may never previously have said
yes.
that a case is, or a claim is, absolutely unmanageable. But at the moment you're on a proposition of law, which is, even if it is unmanageable, that can't be a ground of abuse. But if it is genuinely unmanageable, what's the court supposed to do with it?
Well, what the court is not supposed to do with it is to say that it's an abuse of the process of the court. What the court may say, apart from apologising for its inability to assist the parties with admittedly arguable claims, and the fact that the claimants have a right of access to justice, is to say to the parties, because as this case stands now, it's not really manageable. You either make it, agree between yourselves a way of making it manageable, or if you're not able to agree, or if you're not able to settle, the court then tries to make it manageable in some way. So I understand your point. Your point is, well, what if it's not possible? Well, if it's not possible, I'm not aware of any such case, but if one hypothetically were in that position, you would still not call it abusive.
In effect, not quite. What Judge Mario did in the case whose name I won't attempt to pronounce, where he borrowed from the American jurisprudence the concept of rough justice, he said, I paraphrase, well, this is unmanageable having regard to any of our usual procedures, which are designed actually to establish legal rights definitively between parties. We'll have to go for something more rough and ready, which doesn't guarantee to do that.
Yes.
Can a court, could we do the same thing here?
Well, obviously the court's case management powers are very broad, but broad doesn't mean unlimited. There can be obviously grey areas, for example, in relation to how matters are proved in court. Court obviously is bound by rules of evidence.
I was going to ask this question later, but I may as well ask it now. We have got, if I remembered correctly, over 200,000 individual claims. Claims by individuals who will claim to have suffered damages of a wide variety of kinds, though no doubt they will fall into certain recognised heads. Loss of water supply for a given period, personal injury from having drunk contaminated or been exposed to contaminated water, interruption to their business, small business, and so on. Typically, you would try and deal with that problem when most cases with huge numbers like that in this country have settled by setting up a scheme. But that can only ever achieved, as far as I know, by settlement. Some huge lump sum is produced. It's, in a sense, our version of Renova. And the trust, or whatever it is, doles out money by internal administrative procedures on to establish what is lost. But suppose that isn't possible. The court can't impose a scheme of that kind. You will then have to case manage it in the ordinary courts. What I used to call the district registry, we don't call it anymore, in Liverpool, will have to hear 200,000 cases. Now you'd say, well, a lot of them are very similar. In one sense, that's true, so you can take one or two lead cases to establish parameters, the sort of damages you get, other things being equal, for loss of water for so many days is X. We don't accept that maybe there may be issues about causation. We don't accept that the tailings were capable of causing this or that kind of alleged injury, and so on. But the bottom line, once you've established all those parameters, you will still have, and that may knock out one or two cases in principle, but you will still have tens of thousands, probably over 100,000 individual cases to decide, well, actually, how long was your water supply cut off? You say you suffered depression, how bad was it? You say you suffered business interruption, what are the costs of that interruption? And so on. How does the court manage, let's take a figure out of the air, 100,000 small claims, all individually different of that kind?
Well, the way in which the court manages it, the court does not start with the premise that at some point there will be an irreducible number of claims that have not been knocked out, as you put it, by the earlier decisions of issues of liability, of lead cases, and so on. It does not start at that very end and say, well, it's all pointless, isn't it? We're going to be stuck with at least 50,000 unresolved claims, therefore we'll give up now and we'll call all of the claims abusive. That's not how you do it.
Okay, that's how you don't do it. How do you do it?
How you do it is you address the issues that arise on the pleadings in a logical way and in sizable, manageable chunks, on the basis that as you go along and as and when issues are resolved, the likelihood is a significant number of claims will be resolved. And you hope, ultimately, that it will all get resolved by agreement or by extrapolation from existing decisions. That is how, and I will show you examples, that is how all such group actions, that's the course they all follow. Because the problem that the respondents, or in fact, not as much as the judge has identified, that problem, the notion that the English courts cannot handle 5,000 individual trials just on one case, that proposition, that is true whether you have 100,000 claimants, 200,000 claimants, or 5,000 claimants. It doesn't matter. Yet, there are group actions that are being dealt with day in, day out by these courts with thousands, tens of thousands, and even over 100,000 claimants, other than this case.
And do you say also that one can pray in aid, first of all, the overriding objective,
Absolutely.
and secondly, our broad axe principle of not requiring precision, both of which may be tools for devising what might be quite close to a rough justice system for smaller claims for large numbers of individuals?
There is a possibility of that. I think it would be brave of me to try to delineate exactly what a judge exercising his or her very wide case management powers can or can't do now. Whether one would, through that route, end up where Judge Mario ended up, or somewhere else, but not too far. We don't know. Maybe, maybe not. But there's obviously a separate question in that regard as to whether a claimant, so for example, when presented with the option of making a claim under the novel system, where the deal is basically, here's the damages matrix, you're a washerwoman, you can get X. Take it or leave it. The question of principle is, if washerwoman, Miss Washerwoman, doesn't want to take X because she thinks she's lost 3X, whether if she decides to sue for 3X, taking her chances in court with all of the additional procedural and evidential hurdles which we might thereby have to overcome. Is she behaving abusively, and is she using the court process for a purpose that it's not designed for? That's the question of principle. And
just going back one step to my Lord Justice Popplewell's point, part of the overriding objective and the general matrix is the particular emphasis placed on the parties' duty to cooperate in group litigation.
Absolutely.
And so particularly if there are headline issues of liability to be resolved, when it comes to causation and quantum, it is in everybody's interests to cooperate, if necessary, procedurally in the courts, but then also in terms of the wider settlement picture overall. That's how these pieces of litigation pan out.
They all do. Doesn't matter whether it's 5,000 or 200,000, as I was saying earlier. It doesn't matter. One can see how, for effect, respondents in their position will say, well, how on earth can this be done? One can see that. Forensically, that may carry some superficial force. But if you follow through the logic of that proposition, it really would mean that in any case, where there are frankly, even a few hundred claimants, where a defendant could say, at the start of the litigation, I am going to defend on every single point. Liability, causation, quantification, every single point. That means, inevitably, there will have to be 100 trials for each of those claimants, if there's 100 claimants. Defendant can say that. So does that mean that any defendant in that position can come along and say, well, any claim that has more than, 10 claimants should be seen as completely unmanageable and abusive? How can that be? It's just nonsensical. It's a nonsensical point. And the reason why it's nonsensical is because, although obviously I understand the theoretical lawyer's question as to, well, what would be the position if the case were truly objectively and by universal agreement completely unmanageable? What would be the legal answer? I understand that. It's a valid point, and obviously, and I understand why Lord Justice Popplewell raised it, because we're putting it in terms of unmanageability as not being a legal ground of abuse. But that is not how, in practice, in my respectful submission, one would approach even very large, complex cases.
Well, that's why I wonder whether we're tilting at windmills on this, whether the real question is whether these proceedings are unmanageable, rather than some legal question about what would be the position if they were.
You're probably right, and I think it's my fault for having put it in terms of whether unmanageability is a legal ground, is capable of being a legal ground of abuse. I think that perhaps has rightly prompted your question, but is perhaps not quite the right way of putting it. What I'm really saying is there's simply no basis for supposing that this case, compared to any other group action case, has features that makes it intrinsically unmanageable. And so therefore, if that's right, then the judge's notion of these claims being unmanageable is just simply flawed.
I suspect you want to move on. I don't want to delay you, but your real objection to abuse is, even if, in answer to my Lord's point, these proceedings were properly characterised as genuinely unmanageable, you say abuse is still not the right label. It might be case management stay. It might be something else.
Yes.
But you have a fundamental objection to the idea of, as a matter of principle,
yes,
of proceedings that, assuming they are actually completely unmanageable, you would still say, as a matter of law, that doesn't make them abusive. It might mean that other things have to be done, say a stay of some sort, but not a situation of abuse, if it's an otherwise properly arguable claim, but for whatever reason the court's procedures are simply unable to cope.
My lady, precisely so. And I detect, another thing you would say is, if you accept that it isn't abuse, but is a problem of practical manageability, that's not something that can be assessed at this stage.
Absolutely.
You have to try, perhaps not forever, because then you have to try, see how you go, and then if it really becomes unmanageable, you may have to make some novel decisions at that stage, but not at this stage.
Correct. Exactly so. And so what we say, therefore, is, having looked at some of the authorities that the judge himself cited, is that the fact that there is an extremely large environmental disaster that's harmed hundreds of thousands of victims does not mean that when those victims seek compensation from defendants who have never been sued before, that they are using the court process for a purpose significantly different from the ordinary and proper use of the court process, or that they are unjustly harassing the defendants or seeking to vex them twice, or indeed that their conduct would bring the administration of justice into disrepute. So none of the key indicia of abuse can really be said to apply to a complaint that there are too many claims and it's going to be too complicated. And we've made the obvious point that obviously if it were otherwise, it would be a perverse situation where the larger the wrong, the more serious the tort, and the larger its adverse consequences, the more likely it is that the claim or the claims would be struck out as being abusive on ground of unmanageability.
And the greater the incentive on the respondents to be uncooperative in breach of the...
Well, that's the other unattractive part of it,
objective.
that effectively, as I was saying earlier, it would mean that they could say right at the outset, well, everything is an issue, basically, and it's going to be a nightmare, and therefore strike it out now. What's the point? The third aspect I wanted to draw to your attention is inconsistency with the claimant's right of access to justice. But I don't think that I need to spend time on that. I think that's agreed. Of course, there's a public interest exception in the case of proceedings that are an abusive process of the court, but that, in a sense, just begs the question as to, well, what is abusive, and is it abusive on the facts of this case? And the judge cited the relevant case law in that regard. But it may be worth just briefly spending a few moments on inconsistency with the English court's very wide powers of case management.
Sorry, which paragraphs, just remind me, did he deal with the authorities on right of access?
So he deals with that at paragraphs 49 to 52.
Thank you.
And in particular, you will see the qualification in 51, the quotation from Summers, where there is abusive process. The next topic I wanted to raise was, or move on to, was the judge's, what the judge said about the claimant's failure, as he saw it, to devise a workable procedural mechanism for resolving the claims. This is paragraph 103 of his judgment.
I'm so sorry. Very systematically and to be applauded. You've got so many points and sub-points. Have we dealt with 4 under point 2?
The
range of case management provisions. I'm
on to that, actually.
That's what you're talking about.
That's what, yes, the fourth form of inconsistency, which is inconsistency with the English court's very wide powers of case management. And I wanted to set the scene for that by reminding you of what the judge said at paragraph 103. And this is shortly before he expressed his conclusion of irredeemable unmanageability. It is simply not good enough in the context of group actions generally to seek to outsource all or most of the responsibility for devising a workable procedural mechanism for resolving the claims to the court. In any event, had the claimants attempted to provide more assistance on this point, I am satisfied that such detail would have fared badly under scrutiny. It is not, however, an option to avoid such scrutiny through silence. Those were pretty harsh words in relation to, in the context of the case management of a group action that had barely begun, basically, because of the jurisdictional challenge and the application to strike out. It's a theme that was pressed upon the judge at some length at first instance. I won't take you to the relevant passages, but if you look at paragraphs 406 419 of the respondent's first instance skeleton. That's volume C, tab 4, pages 150 to 156.
What were the paragraphs again? Sorry.
Paragraphs 406 to 419.
Yeah, thank you.
And it's also a point that they maintain on this appeal at paragraphs 90 to 91 and 100 to 101 of their appeal skeleton. I don't need to take those up. Mr. Gibson will take you to those if he wants to. But the point is, it's a point. Obviously, they succeeded. They were rewarded for all of those arguments before the judge, because the judge bought it and found that the claims were irredeemably unmanageable. And they did it by saying almost precisely in the way that you were presenting the potential problem right at the end of the process. Of even however number of manageable trials you can think of, they said, well, okay, we can have a trial of preliminary issues of liability, we can have a trial of some generic issues of causation and quantum, but what are you going to do with this large remnant group of people whose claims have not been dealt with up to that point? They honed in on that, and they said, well, that's game, set, and match, basically, on manageability, because unless you've got an answer to that now, the claims are abusive, essentially. And we say that these, and they made some pretty bleak, almost in terrorem predictions for the English legal system. If you look in particular at paragraphs 412, 415, and 419 of their first instance skeleton, where they described how essentially the English court system would be stretched to breaking point by this case when you get to that very final stage. And we say, and obviously I'm slightly repeating what we've been through already, that these deeply defeatist predictions are wide of the mark because they overlook the court's well-established capability via various techniques, including the making of GLOs and all the selection of lead cases, to provide just and proportionate means of determining the claims of thousands, tens of thousands, or even hundreds of thousands, potentially even over 1 million, as we'll see in a moment in the case that Mr. Gibson, I'm sure, knows very well, the diesel emissions case, where there are, in the case of claims against VW alone, potentially up to 1.2 million claimants, 117,000 of whom have already taken action, with the number growing and growing, and where Mr. Justice Waxman is dutifully, with the cooperation of the parties, identifying issues for decision in the hope that this will narrow the litigation down, narrow down the disputes, enable either full or partial settlement along the way. But just to address what the judge said, where he basically accused the appellants of outsourcing to him, on the strikeout hearing, the job of basically devising what he considered should be a blueprint, detailed blueprint there and then of how the case was going to be run from beginning to end, just to show you what we had said at first instance in relation to that aspect. Paragraphs, this is bundle D, tab 10. If you go to page 443, I'm not going to read it all out, but I just ask you to just skim read paragraphs 493 to 497.
Yes.
And then this is our first excursion into opus. If the opus operator could please go to the trial bundle. I want to take you to Appendix 6, to our first instance skeleton argument. The trial bundle, if you go to the volume scale and go to the claimant's skeleton, and if you go to Appendix 6. I don't know whether the court has opus on its screen, but
We do. Well, I do.
I'm grateful. So you will see Appendix 6. The
Not
page
yet,
number-
but I'm sure it's coming.
It's D tab 12, just the beginning of Appendix 6. Do you have a number for that? It's the supplementary bundle. No, this is in the trial bundle, the first instance trial bundle, not in the appeal bundle.
Then you go down to skeletons, then in.
I've got it.
Yeah.
You got it?
Oh, I see. I could find.
I found it myself. Will it save
Well,
time if we share
No,
it?
I'm afraid
No, I'm assuming that the operator will find it for me.
Operator, have you been able to find it?
operators on the wrong bundles.
It's not evident to me that the version that we've got here includes the trial bundles, although the versions that we were sent did.
What's happened is basically the hard copy material has been sent to you in soft PDF form.
Yeah, we've got all that.
Yes. But then we're meant also to have access to opus.
Yeah, no, I understand all this. I'm just trying to deal with what the operator's problem is.
Yeah, oh, I see, yes.
The operator's problem is that he doesn't have or appear to have the trial bundle. But perhaps he could be shown how to find it. My lord is
That's
trying to
usually
be
my
helpful.
problem.
I think Lady Justice Carr and I have found it.
Yes, I know. Well, I'm just being difficult, but I know that in the future.
I'm sorry, it's such a rarity for me to be able to manage anything electronically. I couldn't help showing off. Sorry.
We're getting there. Because once we found it once, it'll be just quicker
Yes.
for the operator to find it for us.
Sorry. It's headed Appendix 6.
And if you look at what he's open on his screen, he
To
hasn't got.
complicate matters, I don't have an opus.
It's unfair.
Doesn't
It's
matter.
bad luck on him. But
D1? D12.
D12.
Yes. Yes. It's headed Appendix 6.
That's it.
well, there.
Thank you.
There.
So
Well, we're nearly there.
No,
It's got to go to the skeleton
No.
section.
No.
of the
It's
trial
D/12.
you're in the wrong bundle.
bundle. Yeah.
You need to go back to the bundle.
Can I suggest this?
Bundle.
Council must know how to do this. One of them went up to help the operator. I think you go and stay there till he's found it. Sorry, operator, it's very unfair to you,
need to
but
go to trial
we're not trying to give you a hard time at all, but we just need it for the future. I apologise for taking a hard line about this, where my lord and my lady are already there, but I think it'll help in the future.
But it'll save time in the long term.
This is just a list
Yeah.
of the other
Four
Yes.
examples of group litigation which
Yes.
has been satisfactorily managed, you say.
Yes. Yes. But it gives a feel for the issues that arise, the problems
That's it.
that are
Okay.
encountered, including, for example, problems about settlement or monies having been received from other sources.
Yeah,
and
okay,
that kind of
traffic,
stuff.
okay.
So you will see the first case is the traffic bureau litigation with
Yeah.
over 30,000 claimants, all obviously with highly individualized claims for damages because they were based on personal injuries and losses arising out of the disposal of chemical waste. And I'll just leave it to you to glance through.
Well, I can't do that because I can't.
Oh, I'm so sorry. If you go to, forgive me.
Well,
I'm
it
very
is
slow.
a little difficult, really,
It
to
is.
ask the operator to scroll through a document at the speed which suits.
Can I suggest a
judge who's
pragmatic
being
way
asked
about
just
this?
to
We see
cast
the
an
sort
eye
of
over it.
we see the sort of points you're making here. Speaking for myself, I had found this before and looked at it at an earlier stage. If there are very particular points you want to make,
So
just
if we-
make them and I'll write them down.
I'm grateful. I'll do that very briefly.
But it's-
So if
it's pretty
we look, for
obvious.
example, in relation to traffic Euro paragraph 4, operator paragraph 4, I'd be grateful.
Yeah. Yeah.
And then you will see a rather smaller one with 109 claimants, paragraph 5, where there were 10 lead cases. And what the judge said about that in paragraph 5, that approach.
Yeah.
And you will see at bottom of paragraph 7, that was a case where, for instance, the court had to grapple with the existence of parallel settlements by the claimants in relation to the pipeline. If you go to paragraph 9, you will see another case involving 15,000 claimants. Again, another oil spill in Nigeria. And in this particular case, there was, if you look at paragraph 10, there was an order for the trial of 8 preliminary issues. And after the trial and after judgment on that, the parties reached a settlement. And if you then, and I think that's probably enough for that document. And obviously we will include that document in the travelling, the additional hard copy bundle. The court's approach in this context is well summarised in the judgment of Lord Justice Coulson in Jalla and Shell, which your Lordship will find in the additional authorities bundle that we lodged on Friday. I hope you've received that, and I apologise for not having included them in the original set of bundles.
I didn't get an additional bundle, but I have printed them off and put them at the back of F. Is that
Well,
convenient or not?
we have spare copies if you would like that.
I didn't. I saw the one that arrived. I assumed we would be getting a hard copy, as indeed we are.
Yes.
So, the usher will hand them up. I suppose it's an impossible question to answer. If you don't think there are going to be any more additional authorities, it might be sensible, make more practical, just to put them all in the back of F. But the world being what it is, there probably will be more.
I was wondering whether I can promise there won't be more.
No,
Maybe
no.
one or two.
Oh, no,
more.
I'm not going to do what my lord did. I'm going to keep this as a separate bundle. Right. Yes. Okay. So you want us to look at Jalla?
So yes. So Jalla, you will see what the numbers involved there. 28,000 individuals and communities seeking remediation relief against the respondents in the context of a representative action. So somewhat different in terms of the form of the action to the one we have here. But nevertheless, in the context of that, the judge, Lord Justice Coulson, made some useful comments. I don't think we need to look at the particular facts of that case. If you go straight to paragraphs 49 to 51, the particular issue in that case was whether the representative form of action was an appropriate form of action for that case. And obviously that raises some technical questions about the identity of interest between the various claimants. We're not concerned about that in our case, where all of the claimants are individually claimants themselves. But if you look at paragraphs 59 and 50, the judge there essentially summarises the key techniques that the court will use to manage large group actions, including the use of extrapolation across claimants, following careful sampling of lead issues and lead cases. Paragraphs 49 and 50. if you hold on to that bundle just very briefly, you will see that there's another example in a case that Mr. Gibson is well familiar with, the Vedanta case, where I think there were about nearly 2,000 claimants.
That's right. Cooperation in group litigation is of particular importance. Paragraph
Yes.
42. Actually, that's not cited.
Exactly.
But
Paragraph.
I remember reading that.
Paragraph. I was going to draw your attention to certainly paragraph 42 and also 25, 27. There was a debate there as to between different groups of claimants and their respective lawyers as to who should essentially call the shots and drive the GLO. And then you will see what the judge says about that in 25 to 27 and then 29 and then the conclusion, which is more relevant for our purposes at 42. And then just very briefly finally is the Crossley case, the VW case, which is in the authorities bundle, bundle A at tab 10. Another.
Sorry, did you appendix 1 to this judgment?
Yes, so well,
They're just examples
that's just an example of kinds of issues that might arise, and obviously these are specific to the relevant case. That was interesting, that case, I believe. I'm no expert in GLOs.
Which one are we on to now, Crossley, or are we still on Vedanta?
Yes, I think we can put Vedanta away.
No, sorry, when you said that was interesting, that case, which one did you mean?
Oh, sorry, yes, Vedanta was I believe, interesting in the sense that I think the GLO issues were ordered quite early on. I think possibly before detailed pleadings had been prepared. I could be wrong, Mr. Gibson probably knows better, but not that it particularly matters in this context, but it's just an example of how the court's management powers can be brought to bear quite early on in a case. And then the Crossley case in bundle A of the main bundle of authorities at tab 10. So this is
While we dig that up, I take it it's evident from where we are today that there was no pre-action correspondence and there's no relevant attempts between the parties to reach a hypothetical way forward procedurally?
No, I'm not aware of any of that because of the
nature of the argument being raised.
Exactly.
Yes.
Yes.
Thank you.
And certainly there's obviously no defence or anything of the kind. I concede though, because of the nature of the timing of my involvement, I am not totally sure in relation to the pre-action aspect. But I don't believe so. But no doubt the other side will correct me if I'm wrong about that. But there was certainly no evidence, let's put it this way, I'm not aware of any evidence being deployed before the judge or any argument being made to the judge in relation to that aspect. So the next case is Crossley. This is the diesel's emissions case. So these are only claims. These are claims against a number of car manufacturers. And if you pick it up at paragraph 1, this was the first substantive CMC in that GLO case. There were at that point, at the moment, there are about 117,000 claimants on the group register, says the judge. And you will see that in paragraph 4, following developments in the US and this much is common ground, it was established that there are approximately 1.2 million affected vehicles in this jurisdiction. And then in paragraphs 13 to 20, the judge gives an overview of the various types of claims that there are. And then in paragraph 21, he notes that the defendants resist all of the claims. So it's a battle full on all fronts. The judge then, at 24 to 27, identifies the court's broad case management powers. And the particular issue in that, at that CMC was whether there ought to be a trial of preliminary issues. and if so, what those issues would be. And if you go to 94 and 95, it's very hard to find a group action case that doesn't feature Mr. Gibson. It's a bit of a rarity, but you will see there a summary of Mr. Gibson's submission, which was that you can have a staged approach for many things. Well, obviously, I rely on that. I would include within that particular issues. You do not have to show a real prospect of a radically different or a radically shorter trial or no trial before ordering them. It is enough, as here, that they are disputes of a central feature of the litigation, and there are at present a huge bone of contention between the parties. And the judge says there's real utility in dealing with that question now rather than leaving it for trial. And then 97 to 100 are worth looking at as well, because it shows how the court approaches the exercise of its case management powers, including by reference to the possibility that the parties might be encouraged to settle if there were a staged approach to the issues that arise. And the judge concluding that the selection of cases should start now as contemplated by the defendants.
So what the judge here was doing was saying, let's have preliminary issues, but at the same time, in parallel, let's carry on looking at selecting cases for what may happen down the line.
Exactly, because if you and that's obviously very sensible, because if everything proceeded in series rather than in parallel, there would be a great potential for delay.
Yeah.
So, and obviously at the risk of stating the obvious, in any large group action, at the point of commencement of the proceedings, when no defence is being served, and before any engagement by the parties as to the substantive merits of the dispute and how it can be justly and proportionately resolved, neither the parties nor the court will know in precise detail what the disputed issues will be, which of those issues will be common or generic in nature, whether amongst the claimants as a whole or within particular categories of claimant, how the determination of any of the issues should be staged by means of one or more trials, how the parties' disclosure and evidence should be tailored to particular issues, and how fair and reasonable sampling of cases can take place to identify suitable lead cases for trial in order to enable the dispute to be determined justly and proportionately, and to enable effective extrapolation across all claimant groups and claimants. You can have an educated guess about such matters at the very outset of the proceedings, but an inability at such an early stage to formulate a detailed step-by-step case management plan for the entirety of the proceedings, or to identify a comprehensive list of common or generic issues, or to explain precisely how lead cases could ultimately be selected, cannot fairly be equated with unmanageability of the claims, still less an abusive process. So I think I've probably covered that point sufficiently. I want to draw attention to two further observations the judge made on the issue of unmanageability of claims, because that really loomed large in several parts of the judge's judgment. If you look at paragraph 106, that's page 245, tab 9, bundle A, the judge suggested that because of the diversity of the categories of claimant, the number of lead cases would be likely to be far in excess of those selected in any GLO to date. Now, it's difficult to see how the judge could have claimed to have known of the scope of all GLOs ever made, as at the date of his judgment. But even if he were right that the number of lead cases in these proceedings would be higher than in previous group actions, this, with all due respect, is of itself a meaningless statistic. The key point is that the court can be expected to work with the parties in order to devise a proportionate number of lead cases, if necessary by category of claimant, to enable the dispute to be determined justly and proportionately. And again, the same point lurking in the judge's mind at paragraph 135, Roman 2. The judge predicted that the claims, if permitted to continue, would amount to a GLO, the management of which would almost certainly be fatally impracticable. That, we said, was a fundamentally uninformed and premature indication or prediction made at a time when the parties had not fully pleaded their respective cases and had not engaged pursuant to their duty of cooperation in furtherance of the overriding objective. The third aspect that I want to cover, I was going to make some observations about an authority that the other side rely on, which is Lloyd and Google, the Supreme Court decision. But I'm not, bearing in mind the ticking clock, I don't think that I need to take you to that. The short point to note about that case is this. Lloyd and Google was a representative case. It was a case where basically an individual by the name of Mr. Lloyd decided that he'd identified a technical breach of the Data Protection Act by reason of Google essentially transferring data for various commercial purposes without having sought the permission of the owners or users of the relevant iPhones. And he found out there was a technical breach which was capable of supporting a claim for damages. He lost on that because Lord Legate held that damage in the relevant statute was a reference to material damage that had to be demonstrated by evidence as to actual distress or actual loss. And because his claim was one for essentially the conceptual loss of control of data, the judge found that the claim did not fall within the Act. But in the process of describing the various types of action, Lord Legate made the point that outside of the representative context, or when you are seeking loss, you have to plead your loss and you have to prove your loss. And the other side rely on that as saying, well, look, there you go, you need to do that, and you can't do that with 200,000 claimants. But what the judge was not saying, because there are earlier parts of his judgment where he describes the techniques the court deploys in order to manage large group actions where claimants are not claiming in a representative capacity. He points out the possibility of lead claimants and so on to deal with all issues, including issues as to causation and loss. So the short point about Lloyd and Google is there is nothing in Lord Legate's judgment that suggests that the technique, the GLO techniques and the other case management techniques that may be deployed in order to manage large group actions, even in relation to individualistic issues such as causation and loss. There's nothing in that judgment that suggests that those techniques are not deployable and are not part of the armory of the court's case management powers. Quite the contrary. He recognizes those techniques. It's simply that those techniques were irrelevant in the case he was dealing with, because he was dealing with a case where it was said that everybody had the same identical interest, namely the conceptual loss of control of data, irrespective of whether they'd actually suffered any loss at all. So I'll come back to that if I may, if I need to, in reply. But I want to move on to the next bit, which was the third aspect of irredeemable unmanageability that I identified at the outset. One was the central part that it played in the judge's reasoning. The second is perhaps, as per my discussion with Lord Justice Popplewell, my own somewhat inaccurate characterization of the issue as being whether unmanageability is capable of being a legal ground of abuse, whereas in fact it should probably be. Well, I've given my answer to that as well, but in reality it's really more a point that there's no basis in this case for supposing for a minute that the claims would be unmanageable. But the third aspect is an expansion of that same point, which is why, additional reasons why the judge's view that the claims were unmanageable was wrong anyway.
Are you at some stage going to deal with what does appear to have played a part in the judge's mind, which is the practical implications of the parallel proceedings?
I comment to that straight away.
I see.
Exactly. I think that I've picked up essentially 4 themes from the judgment that appear to have been relied upon by the judge as to why the claims were irredeemably unmanageable. The first is what he says in paragraph 78, which is his view that if the English claims were allowed to proceed, the claims would involve closely related group claims moving forward in parallel in 2 different directions, 2 different jurisdictions with many of the same claimants in each, seeking identical remedies in England and Brazil concurrently. That's the first point. I'll call it the sort of the parallel claims point. The second, which is closely related to the parallel claims point, is his view that the risk of inconsistent judgments would be acute in the event that these proceedings were permitted to go ahead in England. That's paragraph 86 of his judgment. So that's inconsistency of judgments. The third is, again, it's really the same point, which is paragraph 90, his view that there was an alarming prospect of a high proportion of the claimants taking steps or reserving the right to take steps to seek compensation in Brazil. So that's, again, in the basket of parallel claims. And then the third, at paragraph 92, his prediction...
Fourth, I think you've got.
Sorry, forgive me, it's fourth. His prediction that there would be what he described as unremitting cross-contamination of proceedings, which would, in his view, lead to utter chaos in the conduct of litigation in both jurisdictions. So that's the cross-contamination point. So if I can deal briefly with the parallel claims point, which effectively, which covers also the alarming prospect of parallel claims in Brazil and England, and those claims being closely related. In expressing the views that are set out of paragraph 78 and 90, the judge appears to have disregarded the fact that the principal action in Brazil, the 155 CPA, I'll shorten it to 155 CPA because it takes less time to say it, and we have to say it quite a lot of times. The 155 CPA had been stayed from January 2017. And so for about 3.5 years, as at the time of the hearing before the judge, and further that it was envisaged to remain stayed for up to an additional 2 years until August of this year.
Last year?
This year. This year. And indeed, the respondents themselves accepted before the judge that the 155 CPA would be likely to remain stayed until at least August 2022. That's, I'll just give you a reference for it. That's their own routes to redress. Bundle C, tab 9, page 245. The last box, basically, in that table. The judge also appeared, and of course you will recall that the 155 CPA is against different defendants, not against these respondents. It's against the Brazilian mine and dam owner and its immediate Brazilian shareholders. The judge also appears to have disregarded the fact that with regard to the substantial minority of the claimants who had commenced parallel proceedings in Brazil, that's just over 67,000 out of the nearly 203,000, roughly about a third or a little under a third, that most of those claims in Brazil were for water supply interruption. Nearly 20,000 of them had been concluded.
Hang on 1 second.
So about 67,000, most of them for water supply interruption. Nearly
Only for water supply interruption.
Excuse me?
Only for water supply.
Mostly.
No. I don't. What I mean is, the mostly which were for water supply interruption, were they only for water supply interruption?
My understanding is most of them was for...
Most of the most. Look, let's say, take a figure out of the air, 67,000, let's say 50,000 are for water supply interruption.
Yes.
Are those 50,000 only for water supply interruption?
Most of them are only for water supply interruption. Most of them are only.
Well, this is a good example where I want to see exactly what the evidence says.
Well, I'll show you. I will show you the evidence for that in a moment. I agree with you. That's one piece of underlying evidence worth looking at, and it's actually the defendant's respondent's own evidence.
Okay.
But let me finish the sort of headline points first. Nearly 20,000 of them have been concluded, and most of the remaining claims.
So most of the 47,000.
So that's leaving about 47,000, and most of those, because of the water supply interruption loss element, are stayed either because of the 155 CPA or because of a specific stay imposed by the appellate court of the state of Minas Gerais under the IRDR procedure, pending an appeal to the Superior Court of Justice.
And this was as at the position as before the judge, as at the time of the judge.
Indeed.
The hearing. Okay.
Exactly. And I'm not aware that that appeal has actually been decided. It's not part of the updated evidence. And it hasn't been, I understand. It's still pending. And so for that reason, most of those claims are still stayed. But let me show you the evidence. So this is...
Well, okay, you say the judge disregarded those facts, but a stay is only a stay. The proceedings are there. At some point, they will be revived. You may say it's taken a long time, but they will be revived. How is it relevant that his point, if it's a good one, isn't met by saying that these proceedings are stayed, unless stayed is equivalent to will never go anywhere?
Yes. Well, there are 2 points, really, that I want to address. The first point is to suggest the idea that all of these claims are actively proceeding in parallel, making the claims in England unmanageable. That's one aspect, which is the point that I'm addressing now by saying those practically all, or most of these claims are all stayed. The main one, as well as all the various small satellite ones. Because that goes to unmanageability, and whether, therefore, in some way, the English court is being disabled from dealing with the issues that arise before it in the English claims. The second aspect, which is what your Lordship is raising with me, which is, well, fine, let's leave aside your point about logistics, as it were. Is there not potentially an abuse argument insofar as those claims are still there potentially and might revive at some point? I agree there's a potential problem there. And the answer to that, in my respectful submission, if the court considers that that is potentially a form of abuse, is to impose a condition that those claimants whose claims against the Brazilian companies are still live, that those claimants should have a choice. If they wish to pursue these claims against the respondents, then they have to discontinue their claims against the Brazilian companies. That would be a proportionate way for this court to deal with the matter.
So you're suggesting that one thing we could do to deal with this problem is allow the appeal as regards this aspect, conditional on a condition of the type you've identified.
Yes. That would only apply, obviously, that condition obviously would only apply to those claimants whose claims are still live.
And that's a concession you are now making on behalf of that group of claimants.
Yes. Well.
And does it include claimants who have additionally claims that they bring in England, which are not covered by those proceedings? Which I think goes back to my Lord's point about whether they were only claiming in respect of water damage.
I'm saying it doesn't matter. If claimant A is a claimant in England, claiming against the English defendants, and claimant A is also claiming for whatever it is, I mean, obviously related to the dam, whatever heads of loss may be, whether less comprehensive than in England or even perhaps more comprehensive, I don't know, unlikely. I'm saying you can say, if you consider that that claimant is behaving abusively, even though he or she may be suing different defendants, Nevertheless, if you say, because of the overlap of subject matter and claim, you can say, well, all right, if you want to pursue your claim against the English defendants, then you can't pursue your claim in Brazil. You're not forced to. You're not forced to drop your case in Brazil. But if you don't discontinue your claim in Brazil, then you're continuing your claims in England will be treated as abusive and therefore should be treated as struck out. You are able to do that. That would be a proportionate way to deal with a very limited issue, which arises only in relation to the sort of 47,000 claimants who still happen to have a claim languishing somewhere in some small claims court or some state court in one of the two states. That would deal with that doesn't trespass onto the question of practical manageability of the English claims, which I already answered, but it deals with any more fundamental abuse concern that the court may have, that these people may be pursuing the same claims essentially or overlapping claims against two different sets of defendants in two different jurisdictions. That would be the short answer.
I saw you made this offer, I think, in a single sentence in the course of your skeleton argument. Speaking for myself, I think I'd quite like to see it formulated, at any rate as a working draft,
Yes.
so that we could see exactly what you say the condition ought to be if we had this concern.
Yes. We will do that, my lord. I think that's a good idea because at times the devil is in the detail. But I hope that I've fairly reflected the kind of condition that could be formulated in order to deal with this element if it were to be considered to be abusive.
I mean, the judge rejected this offer, or floated suggestion, as he put it, at paras 94 and 5, didn't he? Of his
Yes, he did. He did.
So it was. It's not being something that's being raised for the first time now.
No, not at all. No, it's not. I think it's a point that was made before. I think it's known to the other side. They briefly addressed it in their skeleton argument. I think there's no evidence about it.
If it's an abuse, I mean, we're on unmanageability now, but your concession or your suggestion is being made really on a Henderson basis.
It is.
So it's a different issue.
Well, it's a different issue, which is why I was separating. I was pointing out to my Lord Justice Underhill that there are two aspects to that point. One is the manageability point, and the second is the Henderson point.
I see.
But I've killed two birds with one stone, perhaps. But we'll come back with some potential language in relation to that aspect. But I think you've got my point in relation to unmanageability, which is it doesn't affect the manageability of the English claims at all. The other problem.
Sorry, I stopped you from going to the underlying evidence because I just wanted.
Oh, I'm so sorry. Yes,
I wanted to see where this point went. You said the judge disregarded these two facts. The 5.5 CPA had been stayed, and that most of the 67K had been settled or stayed.
So let's go to Bundle D, tab. I'm so sorry, Bundle M. I think let's go straight to the respondent's own evidence. Tab 41.
Yes.
If I just ask you to read 506 to 515.
I'm so sorry, I'm not ready. Bundle N.
Bundle N. M for mother. Tab 41.
Thank you.
Page 2804.
Which paragraphs you want?
Paragraphs 506 to 515. you can see in 510, the ones whose claims were dealt with have concluded was as a result essentially of a settlement.
Hang on one second, I haven't got to...
I'm so sorry.
But hang on, that says thousands of the 20,000 cohort may have concluded. That's not 20,000 had been concluded.
Well, if you look at the quotation in paragraph 507.
Yes. That's that where you've taken your figures from?
Yes.
So he's taken it from his first statement.
Yes.
But how reliable is his first statement? What's the sort of... I don't mean that rudely. What I mean is, what are the resources for his first statement?
Well, it's based, as I understand it, this is the respondent's own evidence. It is based on questionnaires that were filled in by the claimants.
It's explained in Michael's fifth witness statement.
Exactly.
The exercise that's been undertaken by way of analysis of the questionnaires.
If your question to me is, well, how accurate, how sure are we that the data and the questionnaires is accurate? Well, no.
That wasn't my question. Was a more basic one. I had not established, as my lord had, put two and two together and realised this was the Rule 5 exercise, but I now see that it is.
Yes. But your question, my lady, in relation to 510 is a fair one, which is it talks of thousands of the 19,542 were concluded by settlement. You're absolutely right about that. I don't have. I'm not aware of any.
But is the point made about whether they were concluded by settlement as opposed to court decision?
Yes.
I see. Yes.
That's the distinction that's being drawn in 510. Exactly what proportion was by settlement and what proportion was by means of court decision, I'm not sure that we have that data. Certainly not in this particular statement.
Yes, you're quite right. Thank you.
I'm sorry, I still haven't quite read 515. Where does this deal with the... I'm being slow.
So this evidence is specifically relevant to the question of the claims being stayed.
Just one moment, sorry.
Yes, sorry.
I mean, it's not clear to me, but I probably missed something, that the 35,421 most of which include a claim in relation to water supply or water quality. Of that most, it's not clear to me that anyone is saying that that was the only claim made in them. I mean, maybe it was, maybe it wasn't.
That's a fair point. I wasn't, and I'm not suggesting that this particular passage goes to that point. Okay. I was dealing with the point about whether all of these claims are going forward in parallel and will make the trial of the English claim, progress of the English claims unmanageable. That's the point. But you're right. It's perfectly possible. I don't have the data. Maybe it exists in the warehouse of underlying trial bundles as to exactly who claimed what in each small claims court and each state court in Brazil. Maybe. It doesn't matter for my purposes. For the purpose of the point about manageability, because they're all mostly stayed. And one point you should be aware of is that, although I know it's a little bit confusing, and a lot of aspects of this case are somewhat confusing in terms of detail, but you can see that the quotation in 507 refers to 35,000 odd being ongoing, 19,000 odd being concluded, and 10,000 odd being stayed. And then there is a discussion by Mr. Vivan and broad agreement on his part that even the 35,000 so-called ongoing are in fact stayed because of what's happened in relation to the IRDRs. And the reason for that, of course, is that a claimant who's filled in a questionnaire may have thought his case was ongoing, when in fact, because of the pending appeal in the IRDR to the STJ, that case was in fact technically stayed, but may not have been aware of it. But
is this the appeal for the 2,000 versus 1,000 award?
Yes.
Right.
yes, exactly. Yes,
only
it's
the
about
water
water
claims.
loss.
It's only the water claims that we say to stay. I think you said we agree.
Yes, there's a dispute between the experts as to whether, when there is an appeal, as to whether the appeal in relation to the water loss head of claim means that the entire claim is stayed, which is Professor Rose's position, or whether it is only the water claim, that is the water.
If
head
you
of
claim
loss.
for water loss as such,
Yes.
or inadequate quality of water,
Yes.
on the one hand, and also for personal injury or business loss,
Indeed.
we don't know whether there's a stay or not.
we-
But they're going to go ahead sooner or later, aren't they? This is the point I made earlier. The IRDR will resolve the question how much you get for water loss sooner or later. And then if the whole proceedings have been stayed, they'll then revive. Probably the water loss bit will settle, because that's the easy bit.
Yes.
But the other bits won't. So why does this undermine the judge's fear about the same issues being considered in parallel proceedings in two jurisdictions? That's what I don't understand.
Because I'm addressing the issue of manageability of the English claims. What I'm saying is, nothing that had happened up to the point at which the first instance hearing occurred before the judge in Brazil rendered the claims unmanageable, because the main action had been stayed for years and was anticipated to remain.
Yes, but the judge was looking to the future. He wasn't looking at the position at the moment in front of him. He was saying these will be unmanageable as I come to try them, or as somebody comes to try them if they're not struck out.
Yes.
And one of the reasons why they will be unmanageable is that at some point all these proceedings which are stayed in Brazil will start again,
Yes.
and they'll be unmanageable then.
Yes.
Well, how does your point answer that?
Well, my ultimate point, as you know, is, well, if you consider that this really renders.
Well, I've got that,
Yeah.
but what we've moved on from that. I thought you're making a separate point. There really isn't any unmanageability anyway, even if the judge is right,
Well,
because the cases are stayed, but they're not stayed forever,
well,
and they will be unmanageable if the judge is right from the point at which they cease to be stayed.
even if the claims are proceeding in parallel, that doesn't mean that the English claims are unmanageable.
Well, I've got that, but I say I've got that.
But I conceptually, I do accept there could potentially be problems. But whether one is able to say that merely because at some point in the future, if those claims were to continue in parallel with the English claims, it is clear and obvious here and now that the English claims are abusive.
Well,
that's a different
an important
proposition.
point. I mean, you say strike out a draconian remedy. There are all these complications. There are uncertainties. Is your position actually on analysis really just that it was not sufficiently clear? Unmanageability in this context and what might happen in the Brazilian proceedings was just not sufficiently clear to justify a finding of abuse on this basis.
It wasn't clear at all.
Not sufficient
It wasn't clear at multiple levels, because the term unmanageability, what does that mean? Unmanageability can cover all kinds of.
Yes, but we're
potential
dealing with a very peculiar. You are now on a specific kind of unmanageability,
Yes.
parallel claims,
Yes.
and we haven't actually quite bottomed out why the existence of parallel claims causes unmanageability. I think we can all work out some examples.
So let me just briefly summarize, therefore, on what I'm saying. I'm saying, one, the mere existence of parallel claims doesn't mean that the English claims are unmanageable.
Well,
or will
okay,
become unmanageable.
Well, ignore the term unmanageable, because you've got a general point that we can always cope somehow.
Yes.
But do you accept that the existence of parallel claims has the potential to cause real problems? For example, Judge Mario awards X by way of compensation for the same loss on Monday, and the case is coming up in front of the district judge on Friday. And they make different awards in ignorance of what each other has done.
Yes.
That's be unlucky for that particular example to happen very often, but it could. And you can think of lots of different examples where issues are being determined in different and inconsistent ways in different jurisdictions.
I agree with you. That's a potential problem.
Right.
But what I'm saying is whether it's a problem that is serious enough in circumstances where those claims had been stayed for quite some time, where there was no specific evidence as to when the stay would cease, or as to what specific problems might arise in terms of the progress of the English claims. It was an unwise and unjustified.
So it's not.
conclusion.
I just want to be clear how this all worked.
Yes.
You're not saying, which at one point I thought you were saying, that the existence of stays is a complete answer from your point of view.
No, it's not a complete answer.
But you are saying that in principle there won't be for the moment, as long as the stays are in place. There may not be immediate problems, but
Yes.
there could easily be problems in the future. But coming back to what you said earlier, these are problems to which solutions will be found.
Yes, indeed. And as I say, I recognise that you may push the analysis further and say, well, all right, well, let's suppose we get to a point where the two claims are fully back on and are about to be decided simultaneously in two separate courts. What's your position then, Mr. Chuchoy? And as to that, I recognise the problem then becomes bigger. But my ultimate answer to that is the court is able to say, or avoid that problem by saying to those claimants, you've got to elect.
But I mean, so he took this point, the 67,000, as a reason for striking out, you would say, the 200,000.
Yes.
You say it's one of your themes, and I know you're going to include
Different claims.
this.
He ignores
Yes,
the physical different claims. Yes.
That's
Yes, I mean, on any view, I'm not even regarding your questions, Lord Justice Underhill, as even being directed to the 133 or 35,000 who obviously don't have any claim. I'm simply.
No, they're not. But of course, another aspect of the judge's point is other claimants are going to be getting on the bandwagon if this case goes ahead. I have no idea what the limitation problems would be. Subject to any limitation problems, claimants, if these claims go ahead, may join up at any time.
Well, of course, but if claimants.
Sorry, I made the wrong point. Claimants who are in these proceedings may start proceedings in Brazil at any time. That's actually the point I should have been making.
Well, that's a different point. But
you're saying the 133,000 we can ignore because they haven't brought claims in Brazil, but they may.
yes. Well, claimants at any point in time can do all kinds of things that turn out to be abusive later. I mean, I don't think it can possibly be right for the court to start to legislate for what claimants can or can't do in the future on the basis of hypothetical hypotheses as to what might be abusive in the future. If they want to point to a further group of the 160,000 who have also started claims in Brazil, obviously they're able to do that. But obviously the condition possibly could be expressed in a way that takes care of that, so that any form of future abuse of this kind is prevented if that were thought to be abusive.
I'm sorry to bump around like this, but it's just helpful to me. You say, oh, well, of course, if there are other claimants joining, the respondents will know that straight away. Will they? I suppose they will if they have a good information system, because
they know more than us.
The Brazilian defendants will be their subsidiaries, and they can get information from them if their information systems are reliable.
Yes. Well,
Okay.
look,
No, I'm just trying to figure it out.
I don't know whether we have better information than they do. Maybe they do, maybe we do, doesn't matter. What I'm suggesting is, as a matter of principle, intellectually, if this is a problem, and considered to be a ground of abuse, it's conceptually possible to address it in a proportionate manner, so that it only applies to those claimants who are currently still claiming for things that they're also claiming for in England, or potentially, I hadn't thought about it, but it's a fair point, or potentially any claimant who thought he was being clever by waiting until after your judgment to start in Brazil.
But even, can I just move on slightly?
Yes.
To your point about the 47,000, that can be dealt with if they're regarded by us as being abusive on a Henderson and Henderson basis. But that may not be a single category. I can see that Henderson and Henderson arguments might potentially operate differently, as between, on the one hand, a claimant who only has a claim for water rights,
Absolutely.
there and here. And it might well be said, it's not sufficient that you should say, I undertake to stop in Brazil. You shouldn't be allowed to start again here at all on an identical claim. That might not be true of a claimant whose Brazilian claim is only in respect of water rights, but who has a wide variety of other categories of claim which haven't been addressed in civil proceedings in Brazil, but which are the subject matter of English claims. Now, I have no idea whether there are some, many, none who fall in that category.
Yes.
But it may be that, from the point of view of what we can do at the moment, that we can't, even by reference to categories, identify those which are now abusive. But we would not necessarily be saying that an abuse argument cannot be run on a case-by-case basis or a category-by-category basis further down the line, in line with your general point that actually at this stage, the strike out your meeting is one that's applied to everybody on a widespread basis.
That's a valid distinction that you're drawing, because it's specifically relevant in relation to their reliance on the collateral attack form of abuse in the context of the IRDRs. Or rather, that aspect of the case brings out this distinction better, because the IRDRs, as you know, are specifically concerned with water losses. And what is being said is that, well, you can't, for example, claim for more than is already covered by an IRDR in Brazil at the moment. And one of the problems we have, for example, in relation to that aspect of the case is that none of the losses in England, in the English claims, have been quantified. We don't know whether the losses will be therefore consistent with the IRDRs, because the IRDRs, for example, will say you can claim 1,000 for 3 to 5 days of interruption of water. But some claimants may say that they've suffered 20 days of interruption. So does that mean that they can't claim for a pro rata or an appropriate multiple of what's been decided in Brazil? Or there could be other permutations potentially in that regard. But I will come back to that. But you're right. I'm not. So if there were to be a condition in any event, it would have to be expressed carefully so that it only eliminates essentially unfair duplication or what you might call double recovery or a second bite of the same cherry, as opposed to simply potentially just wider categories of loss. But you're right. Another way of potentially dealing with that as well would be for the court not to say that it will not be abusive potentially on an individual basis, depending upon what the particular individual is claiming in the light of what's being either claimed or what's been decided in Brazil. But what can't be said is for the mere existence of that possibility now to be relied upon in limine as applying universally to all claimants and as therefore justifying a strike out of all of it.
Were submissions made to the judge to the effect that it would be important to not to lump the claimants all together?
Yes.
Was there a submission along those lines? Because we have this discussion now and you ask yourself, what's this got to do with the 58?
Yes. Well,
I'm just, was this all thrashed out?
submissions were made in great detail at first instance about the different positions of the different claimants. There was a whole appendix
Yes.
to our skeleton argument that
Yes, I've seen
identified the different positions of the different claimants. Appendix 5,
That's right.
which in fact is in the bundle,
Yes.
I believe, as behind in bundle D, I believe, tab 13, identifying the, tab 12, identifying the different positions of the different claimants.
No, I remember that, yes, thank you.
So yes, there is obviously that point as well. But we will give some further thought to the condition. I have said it, and obviously I'm not saying, I'm not telling you, and you're not going to take from me what you should or should not impose by way of a condition, but we will certainly propose something that we consider to be reasonable and in line with a proportionate way of dealing with any perceived abuse, but it would then be up to the court to consider whether it's even necessary to do that.
Or necessary to do it at this stage.
At this stage, and obviously to the extent I go on record in writing, as it were, in that regard, obviously I will want to be careful enough that I express it in a way that that conforms to our view of what might potentially be abusive. But the point that I was still on unmanageability, I think I'll probably never get off that topic. It's becoming unmanageable in itself. But the point I was simply making was that it's very hard to see how merely having parallel claims that are largely stayed makes progressing the English claims unmanageable. I understand Lord Justice Underhill's point, which I've dealt with. But the next point I wanted to deal with was the judge's perception that all of these claims were progressing in parallel for identical relief. So we've dealt with that in some measure already, but...
Did he say identical relief? I thought he said overlapping relief. He may have said overlapping.
I believe he said identical
No, maybe
remedies.
he did.
Identical remedies.
Paragraph.
He says...
Yes, no, you're right, I'm wrong. I just,
Where did
I
he say
corrected him perhaps to what I thought he ought to have said.
that? Where did he say this?
Yes, in paragraph 78. So that was wrong as well, obviously, because most of the relief in 155 CPA is concerned with in-kind reparatory relief, intended to restore the environment and the infrastructure to the position, to the status quo ante, and that's relief concerned with the protection of diffuse rights, not homogeneous individual rights of the type that are in issue in the English claims, i.e. claims for one's personal losses. There are no English claims for in-kind relief, obviously, in the English proceedings.
But you're picking him up perfectly legitimately on loose language. But if he had said overlapping relief, and the overlap being in the area of homogeneous rights or individual rights, he wouldn't have been wrong, would he?
He would have been wrong about that too.
Oh, tell me why.
Because a claim for relief in relation to homogeneous individual rights in a CPA is only for a generic sentence. There is no monetary relief whatsoever granted. All that is awarded, if the claim is successful, is, and you can see that in bundle G.
Well, I know, of course, I've got that point.
Yes.
But it is a first step. What is anticipated
Yes.
is that when there is a generic sentence, unless the parties have already come to terms by one of the procedures which is part of the TTAC and I forget all the acronyms, the PIM procedure essentially, unless they've already come to terms under that procedure or come to terms promptly following the generic sentence, individual proceedings will then start.
Yes. But again,
indeed,
perhaps your lordship's point, I think, is probably a fair one, which is that I'm judging the judge by a very strict standard of accuracy, which is that even though a generic sentence is going in the direction, as it were, of ultimate monetary relief, nevertheless the relief is not the same as a claim for X.
No, well that's obviously correct.
Obviously I'm not one. I think as a judge one ought to be allowed some latitude or indeed as an advocate occasionally, some latitude with the use of inaccurate language. But it may be a question of degree if there is an accumulation of inaccuracies. But I think I've made my point. The judge didn't quite put it right, and I think I'll move on. I had two other topics: risk of inconsistency of judgments and cross-contamination of proceedings. But I've largely covered this ground in the debate that I've just had with you. But the short point is this, that none of those points per se affects the practical manageability of the claims. Insofar as one were to go beyond that, the practical question of manageability, and one were to look at the question of abuse per se, whether of the Henderson type, collateral attack type, I agree there could be problems, but I've addressed that in part already. I will come back to that aspect in more detail when I deal more specifically with Henderson and collateral attack, and explain why those two headings don't really assist either. Can I therefore move on to...
Just before you do that, can you help me on one point? The phrase cross-contamination, which the judge uses more than once, and which I sort of feel I have a feel for what he meant, but he doesn't actually ever quite say what he means by it. And I just wondered, is it a term which is derived from the oral argument or on the parties' submissions? Did it have a... It's a judge... The judge created the term.
I believe, rather like irredeemable manageability, it's a term that the judge, I'll be corrected, but I believe it's a term. I certainly don't recall seeing that term in any of the written arguments that I've read. But I could be wrong. There may be perhaps the odd reference to it somewhere, but it's certainly not a theme, shall we say. It wasn't a theme as such that was presented as forming a basis of abuse.
How, if at all, does the expert evidence come into any of this? As my lord says, just saying, well, these proceedings were a subject of a stay isn't necessarily an answer, because a stay may be lifted at any stage. But we've got mountains of expert evidence, particularly from Professor Rose, saying whether there's a stay, it carries on forever, whatever. There's never going to be a judgment in 155. Never.
That's a slightly different point. You're right about that.
Just for helping on this, but if that's right, and there's a dispute about that.
Yes.
But if that's right, then does that not factor into this unmanageability, or are you saying no? It's still because my lord says yes. You've got to look to the future. Well, look to the future. Don't we have to start looking at this dispute?
Absolutely. You're absolutely right. Insofar as one is, because there are so many proceedings or types of proceedings in parallel, one needs to be a little careful. So far as the 155 CPA is concerned, that's the main action. Our evidence is that it's highly unlikely in practice that there will ever be a trial of the merits, i.e. a trial of liability in relation to that CPA.
Yes, and I know that's resisted.
And that's resisted,
hotly on the other side.
But even insofar as resisted, our position obviously would be that that's a highly material factor to take into account, even if it's disputed, because obviously the judge can't resolve that on a strikeout. There's that aspect. The questions that my Lord Justice Underhill has asked, however, in relation to the 47-odd thousand,
outside
those are individual claims
I see.
that claimants have issued in their local state court.
But if we broaden it out and look at the non-individual claims, all the others, or those who are involved in the CPA, then doesn't this come into it? Doesn't the expert doesn't looking at the whole abuse picture? Doesn't that come into it?
You're quite right. This is a point I hadn't noted, and so it's an additional point. I had stopped my thought process in relation to the unlikelihood of interference, as it were, between the Brazilian actions with the English claims, by pointing out that the 155 CPA had been stayed for a long time and was anticipated to be stayed for a further 2 years, as at the date of the hearing. But you're right. I could continue the point by saying, and what is more, beyond that stage, frankly, even if there were no overall settlement, there is no real likelihood, no real practical likelihood of there ever be a trial of the issues of liability, because what is likely to happen...
Say your experts, yeah.
But so says our expert, because the likelihood is the structure of the TTAC and the GTAC is such that the parties have a mechanism for referring to the 12th Federal Court, acting effectively as an arbiter or a sort of quasi-judicial role, have the mechanism to submit to the 12th Federal Court remaining disputes in the renegotiation process about, effectively disputes about whether there should be this or that improvement to Renova. In fact, that's how, in fact, a lot of the priority axes, for example, are about whether there should be a program for water quality, and if so, whether it should have this or that feature.
And that mechanism covers individual liquidation, or whatever they're called, liquefication proceedings, or not?
No,
because that's only following a generic sentence.
Exactly. The liquidation proceedings are different.
Yeah.
The other side say that, well, it's a kind of liquidation that's going on. It's not really. The novel system as well is different, and we'll see how it's different when we come to it. But yes, we need to be a little careful. But you're right on the manageability point. If one is trying to project into the future, it's very hard to see why one would not take account of the fact that, well, if there's a credible case that the claim, the 155 CPA, will not realistically ever come to a full trial on the merits, then how is the mere existence of that claim really a source of interference or unmanageability for the English claims? With that, I think I can probably at least make a very quick start, if I may. I'm conscious of the clock ticking.
Yeah, rather annoyingly in this court, there is no clock ticking.
Well, there is a clock, but it's not to be relied upon.
No, well, it's... yeah, I won't make this joke.
It's not a working clock, yes. You're right.
Yes, well, we've got 3 more minutes. Is there, if you've got a short point you want to start on in that time?
Given where the time we've reached, I'm perfectly happy to wait until the come back. May I ask this? This is obviously I ask this with great diffidence, and I know that you have been very generous already in relation to starting early on Wednesday and Friday. I believe that I'm rather behind in what I want to say. Obviously, a lot of what we've discussed will hopefully shorten what I have to say, what I would otherwise have said later. But would the court consider sitting a little early tomorrow, i.e. at 10?
We'll consider that over lunch and let you know. Well, I think we probably should rise now. We will come. It is. You can synchronise your watches. It is 12:58, according to what I'm looking at, and so we'll sit again at 2 o'clock. Fairly prompt.
I'll stop the last stream now, so I've got 90 seconds and